It is the people themselves that shape, in some sense, how the Supreme Court will interpret the Constitution of the United States. The people themselves, I don't believe, change the meaning of this document. And by the way, I held this up in my constitutional law class this week. I didn't have a copy with me, and somebody provided me the copy. I wanted a prop, so that I said, oh, it's the Cato Constitution. I love the Cato Constitution. They insert the word liberty in the Constitution all over the place. So it's a different version of the Constitution. No, it's the same Constitution. But I don't believe that the people change the meaning of this text itself, but there's no question whatsoever that the people have a big influence on what we would call constitutional law, which is the doctrines that come from the Supreme Court of the United States. That constitutional law does change, it does evolve, it is living, and it is influenced by the public's perception of what Jack Balkin is basically said is off the wall and what is on the wall. That is, what arguments are beyond the pale and what arguments are to be respected are influenced. That the question of whether you make an argument that's considered a crazy argument or a crackpot argument or a serious argument depends in part on the validity of that argument, but only in part. It also depends on how that argument is perceived by the general public. And that's why the involvement of the general public in this case was crucially important to us getting as far as we did, as fast as we did. We can never count on the courts themselves to save the Constitution for us or to save limited government for us. That isn't going to happen. It hasn't happened. The courts have let us down repeatedly. They let us down again in this case to a large degree. They are not going to do anything that a critical mass of the American people do not support them doing. They are a highly majoritarian and not a counter-majoritarian institution. They're only slightly counter-majoritarian, but generally speaking, they try to stay within the mainstream of what the people are thinking, and that's the reason why I think it's so important what the American people are thinking. So why is it that 99% of American law professors who considered the possibility of a legal challenge scoffingly dismissed the merits of our challenge as frivolous, and in one case, one particular law professor said that any lawyer who signed a complaint or a brief in the case might be subject to sanctions for having made a completely frivolous argument and have to pay a fine for having done so. A law professor who I respect said that. Why is it? How is it that so many law professors missed the boat on this case? Well, I think there's a lot of reasons for this. I'm not going to be able to go through all of them. But I think one of the most important reasons for this is that law professors tend to come from a similar culture, and they tend to assume that history is on the side of the politics that they all share. There's just a general gut assumption that they are progressive and that history is moving in a progressive way, and that everything that they've accomplished can never be, in their words, undone. Nothing, you can never go back. Everything that you want is negotiable, but everything they've got can never be given up. That's the reason why you can't vote no on one of their progressive policies often enough. They will make you vote no again and again and again and again and again, and then the moment they get a yes vote, at that point, that issue can never be returned to again. That's the end of it. It's done. It's settled. That's in the bank. Let's move on to the next issue now. And that, I believe, is the culture from which most law professors come. And according to that culture, an argument of the kind that we were making in this case is one that was completely alien to them, because they believed it violated this trend of history that was on their side. And therefore, they were quite confident in their view that judges who tend to follow these political trends, and the Supreme Court in particular, who tend to follow these political trends, would never consider these challenges seriously, because as a cultural matter, they were simply off the wall. But I believe what our case shows, what this case shows, the NFIB case shows, is that the tide of history is not invariably moving in a progressive direction. Our case was fought in the realm of public opinion, as well as in the realm of the courts, and in fact, it had to be. And that's the reason why we got as far as we got. So let me just take, I know Ilya just signaled me I was out of time, or almost out of time, actually out of time. But let me just make one further point about how it was we were able to do this in the court of public opinion, because I think it might be helpful to thinking about how to do it in the future. And number one is, I think you have to make a legal argument that appeals to the American people generally, to ordinary folks generally, not just lawyers, in a way that they can understand and appreciate. You can call these things sound bites, and in some respects they are sound bites, but they are sound bites that have to have resonance, and they also have to be consistent with a sound and coherent, genuine legal argument. They cannot actually destroy or undercut the reality of your argument. The first and most important one of these concepts is the title of this book, Unprecedented. This was a term that came from the Congressional Research Service, who wrote a position paper, a study paper, prior to the bill being introduced in the Senate that argued that an individual insurance mandate of this kind would be unprecedented. And what we did in our Heritage Foundation paper is we moved that up to the front paragraph of that paper and led with the idea that this was unprecedented. And the idea that it was unprecedented became the first of the major sound bites. The second one was that we called it the individual insurance mandate. It was a mandate. The law refers to the individual responsibility requirement. Substantively, they're the same, but individual mandate is something that could be more easily understood than individual responsibility requirement. The reason why the word unprecedented did so much work for us is because it means that if something really is relevantly unprecedented, then it means that all the previous Supreme Court doctrine that says one thing or another about it are not exactly on point and therefore don't directly dictate the outcome of the case, and now you have room to run in court. If, in fact, you can establish that it is unprecedented, and many people took issue with our claim that it was, but ultimately we prevailed such that every court who issued an opinion about this case admitted that it was an unprecedented case of first impression. All right, so the last point I'm going to make is that what this tells us is that think tanks alone, as clever as they may be, and clever lawyering alone, as clever and as smart as lawyers can be, are never going to be enough to restore the lost Constitution. And by the lost Constitution, I mean the Constitution with all of its parts, not just some of the parts, being enforced. And that's the reason why the social movement like the Tea Party is so important. Whether they're called the Tea Party or not called the Tea Party, none of this would have happened if a political movement had not formed around this issue. And I was myself out in front of the Capitol during a Tea Party rally against the bill at the weekend in which the bill was first passed by the House. When the bill was up to a vote in the House, I saw what that rally was like. Had that not been the case, and then had talk radio not picked this up and run with it in the public domain, using these concepts that were able to be translated to the American people, this would not have happened in the Supreme Court. It's what made our otherwise valid arguments sellable in the Supreme Court. They had to be valid arguments. If they weren't going to work. But being valid arguments alone were not going to be enough if it wasn't politically acceptable for the court to reach that conclusion, which we made it politically acceptable, or I should say that the American people, a strong subset of the American people, made politically acceptable. So now the fight is on for the political soul of the United States. This book describes a crucial battle in that fight. And in this book, in this battle, we gain ground. In this battle, we gain ground with this lawsuit, but the war continues. And you should read this book, I believe, as a case study of how that war needs to be waged and by whom.